Motorola Solutions has filed a lawsuit in the Delaware District Court asking the court for a declaratory judgment that Motorola Solutions is not infringing patents held by Round Rock Research. Now, in the United States and in most other countries, the courts are set up to settle disputes. Now, here in this case, we're talking about a dispute over patent infringement. Now, the courts have to have an actual case or controversy, a dispute for the court to resolve. The court then decides and removes this cloud of uncertainty in finding a declaratory judgment, whether the company is infringing or is not infringing. This is a case brought by Motorola, who is not the patent holder here. The patent holder is Round Rock Research. Motorola is the company wondering whether they're infringing or not. So they're potential infringer. This is not brought by the patent holder. This is a case brought against the patent holder. And in this situation, the patent holder has to file an infringement suit as a compulsory counterclaim. Otherwise, Round Rock Research would lose its rights to ever assert patents against Motorola if it did not respond in this lawsuit and file its own claims of patent infringement by Motorola. Now, not only can companies that are potentially infringing patents bring these declaratory judgment lawsuits, but there's an incentive for them to do so. One of the incentives is the venue. Motorola here can select the district court in which to file suit and may gain a home field advantage. In patent cases, very often there are courts that are well known to be friendly towards the patent holders and others that may be more friendly towards the defendants, the potential infringers. So in this case, Motorola may be filing in order to gain an advantage by selecting the district court that they want to have the case heard in. Also, by removing this air of uncertainty over the patents, they may be able to avoid triple damages. If there is a case later of willful infringement, then Motorola is obviously acting to eliminate any concern that they're infringing the patents and they're not willfully disregarding the patents. Now, what triggers these lawsuits? Now, as we said, it has to be a case or controversy, a cloud of uncertainty. Now, these lawsuits can be easily triggered. They're often triggered by companies that are selling patents and sending letters or emails or contacting a potential buyer of a patent, alerting them to the patent number. They may just be saying this patent's for sale, but they may also trigger a controversy as to whether the company is infringing by other language that they place in this letter. Now, a definitive accusation of infringement is not necessary. Okay? The courts have held that even, minor accusations or controversies can be created with the most innocuous of language. You may be able to point to a product or identify a product, identify the patents. You may, by wording an email to a company when sending them patents that you may be selling them, highlighting the patents and explaining how the patents may be interesting for their products. This may be sufficient to, in some courts, to create a sufficient controversy to bring a declaratory judgment suit. So patent sellers are often concerned about this issue of they want to avoid triggering declaratory judgment lawsuits. So what they need to do is they need to be careful when sending out patent numbers to potential infringers or potential buyers. The problem here is that a small patent holder, a small inventor, may be forced to face a huge corporation in court if they trigger one of these lawsuits. The legal fees for responding to these lawsuits can obviously be significant. Often, patent cases, the costs for each side are measured in millions of dollars. And if you're a small, independent patent holder and you're facing one of these suits against a huge corporation, you may not want to incur those costs. How do you avoid these costs? Well, one thing you can do is to engage via a third party. You don't approach the potential infringer, the potential buyer directly. You do this via a broker like Tynex. This is something that we do all the time. Then we carefully craft the letter and the message to try to avoid any controversy being created or any accusation of infringement. And we declare that the purpose of the approach is merely to offer patents for sale, not assertion or accusation of infringement. So, selling patents is a legal minefield, and small inventors can easily trigger a costly lawsuit when the potential buyer triggers a request for a declaratory judgment from the court. The best advice is to engage professionals when selling patents, if you don't want to find yourself facing a declaratory judgment lawsuit.